So I've been involved with 2 transactions lately where I'm representing the purchaser of a property, and that purchaser is inquiring if they can back out of the existing deal prior to closing. And they're often citing concerns about COVID-19 and the state of the world. So this is completely normal in periods of flux, whether economic, political, or social. Realtors will certainly see a greater number of collapsing real estate deals or questions relating to the potential collapsing of those deals as uncertainty starts to set in. Well, rest assured, there are many properties still closing and buyers continuing to purchase. So the ability to access lawyers, conveyancers, land title office, and financing is still there. The way we interact with these parties is shifting towards more digital means, and there's still many options to maintain personal distance and safety during these times of social distancing. So in this video, I'm going to review the common law in British Columbia regarding collapsing real estate deals. It's important to note that this video is not intended to be a substitute for independent legal advice. I strongly recommend that you seek independent legal advice for your specific situation, especially if it's involving a collapsing deal, as each situation is fact specific. So there are 3 common law reasons why a real estate deal would collapse in British Columbia. First one being the default or breach of contract. Number 2 being a misrepresentation or mistake. And 3, lastly, frustration, a legal term called frustration. So let's start with number 1, the most common one, default or breach of contract. And that typically arises in the following situations. So let's say the seller no longer wishes to sell or cannot sell the property in accordance with the terms of the contract of purchase and sale. For example, they do not have the proceeds to clear title and deliver clean title to the buyer. Another scenario could possibly be the buyer is unable to complete the purchase of the property, often because lack of financing or the inability to come up with a down payment. Third reason could be the buyer does not want to complete the purchase, often because of new information or new economic, political, or social reasons. For example, COVID-19 coronavirus. Or one party of the contract is in breach of one of its obligations under the contract. For example, the buyer fails to deliver the deposit monies on time, or the seller is not willing to deliver or unable to deliver vacant possession when the contract requires it. So the breach can be an actual breach, one which has occurred, or an anticipatory breach, where the breaching party demonstrates by words or by conduct that they do not intend to complete the transaction contemplated under the existing or agreed upon contract. So if a default or breach of contract does not relate to a fundamental term of the contract, then the innocent party is generally required to still complete the transaction and then can sue for damages resulting from the breach of default. For example, if a warranty that was made in the contract happens to be untrue. So there's a number of remedies that the innocent party would seek if there is a default or breach of contract, and those may include in asking for the deposit monies, damages, or occasionally specific performance. Real estate contracts often specify the consequences of certain kinds of defaults, and they may provide specific remedies in the contract that are available upon certain types of defaults. So you should always consult your lawyer, realtor, and really understand the contract. Number 2, misrepresentation or mistake. So a real estate transaction could also collapse because of a misrepresentation, usually by the seller or their realtor. So there's 3 different types of misrepresentation in the eye of the law: innocent, fraudulent, and negligent. The party who relies on the misrepresentation may be entitled to remedies under all 3 types of misrepresentation. So the legal doctrine of mistake refers to a situation where either one party or both parties are mistaken about a fundamental term of the contract. Generally speaking, for there to be relief under the doctrine of mistake, the mistake must have a common or mutual mistake where both parties were mistaken on a fundamental term of the contract. For example, where both parties make the same mistake in relation to a fundamental term of the contract in the case of a common mistake, or the parties are mistaken as to each other's intentions or obligations in the case of a mutual mistake. In rare instances, there may be a relief for a unilateral mistake by one party. However, the other party must have known or ought to have known about the mistake. The remedy for misrepresentation can be damages and/or rescission. And lastly, the legal term frustration, which was number 3 of our reasons why a deal would collapse. So a contract is known to become frustrated when parties to a contract did not and could not foresee an intervening event, which makes the performance of the contract impossible. So for this situation, I find this hard to believe that frustration would qualify during COVID-19 right now, because the ability to close is still possible. There's still access to lawyers, land title office registration, financing might be a bit slower, but there's still banks and financing companies able to deliver funds. So for the doctrine of frustration to be applicable, 3 things must be present in the given situation. 1, the parties, or either of them, are unable to carry out the contract or parts of the contract. Number 2, the intervening event causing such inability to perform was beyond the control of and not the fault of either party. And lastly, number 3, the parties did not make any provision in the contract itself to deal with such an event or the consequences flowing from it. So generally speaking, it's very challenging to successfully argue that a contract has been frustrated. The remedy for frustrated contracts would or may include termination of the contract and restitution, which I'm not going to cover in this video. And the remedy for frustrated contracts. So let's take a deeper look into remedies. So what remedies are available to an innocent buyer or seller in the face of a collapsing deal? So there are 4 common legal remedies available to the innocent party with a collapsed real estate deal. 1, the most common ones, the deposit. 2, damages. 3, rescission. And 4, specific performance. Before an innocent party elects on how to proceed, once there is a breach or a deal begins to collapse, they should certainly obtain independent legal advice to ensure they understand the remedies available to them and that they do not inadvertently do something that changes their legal position or limits other remedies available to them. So I'm going to talk briefly about each remedy, just give you a quick overview. So deposit, pretty straightforward. The innocent party is usually making claim towards the deposit. However, it should be noted that if the deposit is being held under the Real Estate Services Act, which I'd say 99% of deposits are in British Columbia, it cannot be released without the consent of both parties, meaning the innocent party may need to obtain a court order for the release of the deposit if the defaulting party does not agree that the deposit can be released to the innocent party. So generally speaking, depending on the terms of the contract, an innocent seller is entitled to retain the deposit whether or not they suffered any damages. The exception to this is instances where the deposit is so large that it cannot be considered a deposit anymore. Let's look at damages. What are damages? So an innocent party may take claim for damages they have suffered as a result of the other party's breach of contract or misrepresentation. If the innocent party is also retaining the deposit, they can claim damages in excess of the deposit amount. The claim for damages can be common law damages or in lieu of specific performance. If a buyer has failed to pay the deposit when due and payable, a seller can seek an award in the amount equivalent to the deposit as either an action for damages or debt. And lastly, we have the remedy of specific performance. So specific performance is a remedy where the court orders the defaulting party to complete the transaction as originally contemplated in the contract. The remedy of specific performance can often be available in limited circumstances where the property or facts of the transaction are so unique that the damages will not be sufficient. Remedy is not very common as the threshold of proof on all parties is very high. So although there may be a higher number of inquiries about collapsing deals during COVID-19 pandemic, buyers and sellers should be aware that real estate transactions continue to complete and close. Lawyers and notaries have been working alongside LTSA and the Law Society to ensure systems are in place for transactions to continue closing even when clients are in self-quarantine. So while some law firms and notaries have closed, the majority of them remain open and continue to remain open as it is an essential service. Most offices have taken steps to protect their employees and clients, such as having a limited number of employees in the office, having many people work from home, and changing the procedures about interacting with clients and abiding with social distancing guidelines. That Land Title Office has also temporarily approved the swearing of affidavits and oaths remotely by video conference for the purposes of land title applications. So overall, it's important to remember the usual principles of contract and common law still apply during the COVID-19 pandemic. I wouldn't worry too much. If you have any questions about real estate, purchasing, buying, selling, residential, commercial, contact myself, Dustin Miller, 778-678-9815. I'd always highly recommend you check out my website, victoriamarket.ca, for all the latest and greatest stats, sales, and news about real estate in the Greater Victoria area. Thanks for watching. Hope this was helpful, and have a great Easter long weekend.